I can actually read this judgment for 6 hours without a paper in my hands. Okay. So why am I telling you this? If you do not hear me read out your submissions verbatim, please wait for my judgment. I have, as a general statement, taken into account your submissions. In my understanding at this point, the key question to determine is whether the prosecution has discharged its burden of proof, which is beyond reasonable doubt that each or both accused person murdered the deceased. It is strict law in criminal cases that the burden of proving a crime lies on the prosecution to prove the ingredients of the charge beyond reasonable doubt. This is explicitly set forth in the provisions of Section 107, 108, and 109 of the Evidence Act, which is Cap 80 of our laws of the land. These provisions of law speak to proof of the existence or otherwise of a particular fact in relation to the offense under consideration. The burden remains on the prosecution throughout the trial. The rationale behind the proof of the prosecution case beyond reasonable doubt is based on provisions of Article 50, Sub-Article 2 of the Constitution of Kenya 2020, which stipulates that each person has a right to a fair trial, which includes the right to be presumed innocent until the contrary is proved. There is ample judicial authority underscoring this principle of burden of proof. I draw your attention to two cases that I made reference to. A case from the Supreme Court of Nigeria, Bakare versus State, and I'll just read a bit of what the court said in that matter, that proof beyond reasonable doubt stems out of the compelling presumption of innocence inherent in our adversarial system of criminal justice. To displace the presumption, the evidence of the prosecution must prove beyond reasonable doubt that the accused person is guilty of the offense charged. Absolute certainty, however, and please carry with you these words, they may be important later. Absolute certainty is impossible in any human adventure, including administration of justice. Proof beyond reasonable doubt means just what it says, but does admit a high degree of consistence with an equally high degree of probability. Allow me again to draw your attention to the case of United States versus Smith. Long citation, you can pick it. Long quotation from that case, but very important. And this is what the court had to say. The burden is upon the state to prove beyond reasonable doubt that the defendant is guilty of the crime charged. It is a strict and heavy burden. The evidence must overcome doubt concerning the defendant's guilt, but it does not mean the defendant's guilt must be proved beyond all reasonable doubt. A reasonable doubt is a fair, actual, logical doubt based upon reason and common sense. A reasonable doubt may be either from the evidence or lack of it. Reasonable doubt exists when you are not firmly convinced of the defendant's guilt after you weighed and considered all the evidence. A defendant must not be convicted on suspicion or speculation. It is not enough for the state to show that the defendant is probably guilty. On the other hand, there are very few things in this world that we know with absolute certainty. The state does not have to overcome every possible doubt. The state must prove each element of the crime by evidence that firmly convinces each of you and leaves no doubt. The proof must be so convincing that you can rely and act upon it in this matter of the highest importance. If you find there is reasonable doubt that the defendant committed the crime, you must give the defendant the benefit of doubt and find that the defendant is not guilty under the circumstances. Moses Nato Raphael versus Republic. Reign states an important point. Burden of proof lies on the prosecution. But that takes note of exceptions. A few instances the law may shift the burden to an accused person. And they quote a celebrated case of Wilmington, which is cited under 1935. Allow me to take a bit of time on these authorities because I'm sure the lawyers understand the importance. It does recognize that although the burden of proof is on the prosecution, as we put it in our world, by every general rule there is an exception. And so, throughout the web of the English criminal law, one golden thread is always to be seen, that it is the duty of the prosecution to prove the prisoner's guilt, subject to the qualification involving the defense of insanity and to any statutory exceptions. If at the end of the whole of the case there is reasonable doubt created by evidence, as I've already said, the doubt goes to the benefit of the accused. May I again just draw your attention to Nyanjui versus Republic. I am now back home. I've been to Nigeria and UK. I've come back home. Criminal Appeal number 96 of 2021. But that quotes our otherwise well-known jurisprudence guru, Lord Denning. Miller versus Ministry of Pension, 1947, All England's Law Reports. What did Lord Denning say? That a degree is well settled. It not reach certainty, but it must carry a high degree of probability. Beyond reasonable doubt does not mean proof beyond a shadow of doubt. I'll read that again. Beyond reasonable doubt does not mean proof beyond a shadow of doubt. The law would fail to protect the community if it admitted falseful possibilities to deflect the course of justice. If the evidence is so strong against a man as to leave only one remote possibility in his favor, it is possible, but not in the least probable, the case is proved beyond reasonable doubt, but nothing short of that will suffice. I have said enough on reasonable doubt. Having said what I have said and set the law as it is, I shall now turn to the charge before this court. It is a charge of murder. Section 203 is read together with Section 204. The pertinent section is 203. I quote it. Any person who of malice aforethought causes death of another person by an unlawful act or omission